Whistleblower number one, known as William Shapley, a very credentialed IRS supervisory special agent who works in the criminal investigatory team, has blown the whistle. And we heard him speak before, but we didn't get a full copy of his transcript from when he sat down behind closed doors with Congress. We do have that document now, along with his affidavit. And this is the document that reveals more evidence about the Biden crime family, because Shapley, along with Mr. X, who apparently, as we know, was a subordinate of his, they were working on the Biden crime family case. They were specifically targeting Hunter Biden, wanting to go investigate his storage facilities, get access and search warrants, go and take an investigation from covert to overt to have contact with him so that they could investigate him and potentially bring charges, saying no one is above the law. But after they began blowing the whistle, they were outed. They were called and reassigned by the IRS and the DOJ themselves. And so now they're making their voices heard. This is the statement of Gary Shapley, whistleblower number one, who's got the goods on the Biden crime family. Here is what he said. I, Gary Shapley, hereby provide the following statement. I make this statement to supplement the testimony I've already given. He says, beginning in January 2020, I was assigned to work on the Hunter investigation. And January 2020 would be the year of the election. November 2020 is when we're voting. So he's going to be assigned criminal investigation for the Department of Treasury. I supervise investigations, including of Hunter. I continued in that role until I was removed, May 2023, after I provided protected whistleblower disclosures about the mishandling of information, including Hunter Biden. There was conflict of interest that I saw. I saw preferential treatment, deviations from the norms of investigative procedures. And I saw conflicting information provided by Merrick Garland of the United States Department of Justice to Congress related to the independence of David Weiss, the attorney from Delaware. David Weiss, the Delaware attorney, was supposedly this independent person who had authority to do whatever he wanted. Whistleblower says Merrick Garland lied about that. He did not have that authority. Most recently, Shapley says former Attorney General Bill Barr provided an interview in which he stated that information provided by CHS concerning an alleged bribery scheme by Biden was received through the Pittsburgh Attorney's Office and was determined it was not likely to have been disinformation. Barr said it was provided to the ongoing investigation in Delaware. Now, neither I, nor the line agents, nor the FBI agents were ever provided that information that Attorney Barr recently referenced. Nobody checked it out. Prosecutors never provided that info to us. As such, neither us nor the FBI agents working with them were provided the opportunity to conduct an investigation. We requested to be a part of the briefings, but our requests were denied. If IRS investigators had participated in those briefings, we would have ensured that the proper investigative steps were conducted to make sure we were getting the veracity of the investigation into Hunter. He says during a criminal investigation, it is pivotal. All leads are shared, but they weren't here. This is another example of prosecutors, okay, from the DOJ, not even the IRS people or the FBI people, just so we're clear about this. And we saw this yesterday with this other IRS agent. The prosecutors, like Leslie Wolf, who have to interface with the actual filing of the charges. These investigators, IRS and FBI, they're just witnesses, essentially. They're just investigators. Then they give it to the government prosecutor, and the prosecutor brings the charges forward. So they can act as the ultimate roadblock, which is exactly what's happening. It is more likely than not that there are more examples of information that prosecutors concealed from investigators in addition to what I've already shared. And so as a result of this CHS information being concealed by prosecutors from the IRS and from the FBI, we were unable to follow alleged criminal activity that we would normally follow. Agents from the IRS and the FBI confirmed that to the best of their knowledge, this information was never provided and no known investigative steps were taken or assigned to Hunter to substantiate it. All right. Total cover-up by the DOJ is where this is coming from. Signed by Gary Shapley. And so let's go through the opening statement here today. Part of a set of whistleblowers that came forward. The other whistleblower is known as Mr. X. We don't have a name for him. But Shapley has identified himself. Gary Shapley Jr. He shows up to Congress. Bunch of people are present, including lawyers for the majority and the minority. the Republicans and the Democrats. And they go through the normal litany. Good morning. We're here today for an IRS deposition. Gary Shapley is here. Now, I want to go over the whistleblower rules, and just so we're clear how these depositions work, we're going to speak clearly, all right? And we're going to cover a wide range of topics. Do you understand? Yes. Is there any reason why you can't tell the truth? No, no reason. And they give him the criminal warning. You know, Mr. Shapley, that if you're lying to us here, if any of this is dishonest, we can charge you with a crime. Criminal prosecution for perjury and making a false statement. Mr. Shapley says, yes, I do. He says, you also know this is confidential, right? Yeah. He says, you know we can investigate this stuff, right? Yeah. Very good. Now, with all of that out of the way, let's begin with testimony. He says, Mr. Shapley, my name is Gary Shapley. I am a supervisory special agent with the IRS. I've been there since 2009. I've been acting special agent in charge since 2018. Okay, long time, 2009, 2018. There is no reward for me becoming a whistleblower. The only win for me is not being fired or arrested or retaliated against. It's all bad. He says, before October of 2022, I'd received the highest awards available to me at my agency. I was senior leader, assistant special agent of charge in Chicago, highest performance rating that year, which was outstanding. And I was planning to transition to a new position in headquarters for international collaborations. I had led, planned, developed, executed warrants in dozens of countries. I've recovered over $3.5 billion for the U.S. government. Whew, that's a lot. And he says, you know, despite all of that work, since October 2022, the IRS Criminal Investigations Unit has taken every opportunity to retaliate against me and my team. I was passed over for a promotion for which I was qualified. The special agent in charge and the assistant agent in charge have sent threats to the field office, suppressing additional potential whistleblowers from coming forward. Even after the IRS senior leadership had been made aware on a recurring basis that the Delaware U.S. Attorney's Office was acting improperly, they acquiesced to a DOJ request to remove the entire team from the Hunter investigation. All right, DOJ putting the pressure on the FBI and the IRS. This team's been investigating it for over 5 years. Passing the buck and deferring to others was a common thing. Now, after you hear my testimony, Congress, I believe you will understand why my conscience would not be silenced. My oath of office would have been unfulfilled if I did nothing. I went from a senior leader here to a pariah, and the only thing that happened in between was that I blew the whistle. Now I'm blowing the whistle because the Delaware U.S. Attorney's Office, which was assigned to investigate Hunter, the Department of Justice Tax, and the DOJ itself provided preferential treatment and unchecked conflicts of interest in an important and high-profile investigation of the president's son, Hunter Biden. The mission of the IRS criminal is to investigate criminal violations. That mission can only be met if we all encounter the same process. If search warrants or witness interviews that include their actual names are not allowed, that's a deviation. And yesterday we learned that whistleblower 2, Mr. X, explained that in detail for us. When they were going to get a search warrant, which is a part of the official record, then they wanted to include Hunter's name on there. But the DOJ said, maybe we can just, redact that out. And Mr. X said, what the heck are you talking about? We've never done that before. The case agent on this case is one of the best agents in the entire agency. Without his knowledge and persistence, the DOJ would have prevented the investigative team from collecting enough evidence to make any informed assessment, which ultimately included even the DOJ agreeing on the recommended criminal charges. So Gary Shapley, the IRS whistleblower, says, I am alleging with evidence that the DOJ provided preferential treatment, slow-walked the investigation, and did nothing to avoid obvious conflicts of interest in this investigation. I have absolutely no political activities in my past. I vote in the general election and recently voted in the midterms because of an interest in the process for my children, who I took to witness one of the pillars of this nation, the right to vote. I have never given $1 to any campaign. Never attended a campaign event at any level of government. Never had a campaign sign on my car, lawn, etc. I do not own, have never owned a t-shirt or a hat with any election topic. I vote for a candidate, not the party. I voted for presidents with both R's and D's. Now I speak on this topic so I can try to head off time that might be spent on it. In the end, a fact is a fact, regardless of the political affiliation of the person who brought it to you. I am hoping the whistleblower process will allow me to give this protected disclosure and leave it to you to make your determinations based on what my testimony says. And I respect this institution, and I have faith that the issues I raise will be considered appropriately. And I beg of you to protect me from the coming retaliatory storm. I beg of you to protect me from the coming retaliatory storm, says Gary Shapley. You are my only hope, and your actions send a message to all those out there that see wrongdoing but are terrified to bring it to light. Prayers for Gary Shapley for bringing this to light for all of us. Very courageous and heroic man. In this country, we believe in the rule of law, and that applies to everyone. There is not a two-track justice system, depending on who you are and who you're connected to. But the criminal tax investigation of Hunter, led by the U.S. Attorney's Office for Delaware, has been handled differently than any investigation I've ever been a part of in the last 14 years of my IRS service. Some of these decisions seem to be influenced by politics, but whatever the motivations, at every stage decisions were made that had the effect of benefiting the subject of the investigation. These decisions included slow-walking investigative steps, not allowing enforcement actions to be executed, limiting investigators a line of questioning for witnesses, misleading investigators on charging authority, delaying any and all actions months before elections to ensure that the investigation did not go overt, well before policy memos mandated the pause. These are just a couple examples. Shapley says the investigation into Hunter, codenamed Sportsman, was first opened in November of 2018 as an offshoot of an investigation that the IRS was conducting into foreign-based amateur online platforms with bang-bang material in it. Special Agent so-and-so developed the investigative lead and was assigned to be the original case agent. Foreign-based amateur online bang-bang platform. Hunter gets caught in that mix. Then in October 2019, the FBI became aware that a repair shop laptop, allegedly belonging to Hunter, and the laptop might contain evidence of a crime. Yeah, a lot of them. And you can ask our friends at MarcoPoloUSA.org about that. They've chronicled it all. The FBI verified its authenticity in November 2019. They matched the device number against Hunter Biden's Apple ID cloud. So what a total scam this was. The FBI knew it was his laptop because they were in possession of it. And they didn't release any information about it, respond at all to the letter from the CIA, or the former CIA officials, the 51 so-called intelligence experts. So they knew it was true. Joe Biden's campaign knew it was true because Hunter knew it was true. Presumably, Joe talked to Hunter, and Hunter wouldn't lie to his dad, right? So they all knew it was true, but the FBI never told it to us, and they all covered it up in a massive hoax. CIA drafted the 51 letter, and the Biden people told us it was Russian disinformation. And Anthony Blinken colluded with Mike Morrell, former CIA, in order to get it all done. Anthony Blinken got promoted to the Secretary of State position, and now Hunter's palling around at the White House. Amazing. When the FBI took possession of the device in December 2019, they notified the IRS that likely contained evidence of tax crimes. So they also knew it was criminal. The special agent so-and-so drafted an affidavit for a search warrant, which a judge approved that month. In January, I became the supervisor of the Sportsman Hunter case. The group known as International Tax has 12 elite agents. International Tax Crimes Group, the ITFC. Elite agents who were selected based on their experience and performance of complex, high-dollar international tax investigations. Now, this team, including the co-case agent, me, were working closely with the FBI and Delaware and Department of Justice tax in bi-weekly prosecution team meetings. But it soon became clear to me that this case was being handled differently than anything I'd ever seen before, and he'd been there for some time. As early as March 6, 2020, I sent a sensitive case report up through my chain of command at the IRS, reporting that by mid-March, the IRS would be ready to seek approval for physical search warrants in California, Arkansas, New York, and D.C., all locations of Hunter. Arkansas is where his new baby is. Special Agent so-and-so drafted an affidavit establishing probable cause for the search warrants. We also plan to conduct 15 contemporaneous interviews at the same time. But after former Vice President Joe Biden became the presumptive Democratic nominee, In early April 2020, career DOJ officials dragged their feet on the IRS taking these steps. By June 2020, those same career officials were already delaying overt investigative actions. This was well before the typical 60 to 90-day period where they would historically stand down before an election. It was apparent, though, that the DOJ was purposely slow-walking the investigation. On June 16, 2020, Special Agent so-and-so and I had with our chain of command up to the Director of Field Operations. I pointed out, I said, look, if normal procedures had been followed, we already would have executed these search warrants. We already would have conducted interviews and served these documents. But my IRS chain of command said, well, we got to defer to the DOJ. So Gary Shapley says, thus, I became the highest ranking IRS leader to participate in our prosecution calls. We talked about specific case strategies. We discussed the investigation with the DOJ in Delaware. And from October 2020 until October 2022, I was the IRS manager who interacted directly with David Weiss. So he's a direct witness to this investigation. Even after investigative steps were denied, enforcement operations were rejected by the DOJ, leading to the election of November 2020. We continued to obtain further leads in Hunter's case and prepared. In August 2020, we got the results back from an iCloud search warrant. Unlike the laptop, these came to the investigative team from a third-party record keeper and had a set of messages on it. The messages included material we clearly needed to follow up on. Not good. Nevertheless, the DOJ prosecutors denied investigators' request to develop a strategy to look into the messages, and they denied the investigators' suggestion to obtain location information to see where the text came from. One example, we obtained a July 30th, 2017 WhatsApp message from Hunter Biden to Henry Zhao. And here is what the text message says. I am sitting here, Henry. I am sitting here with my father, and we would like to understand why the commitment made has not been fulfilled. Tell the director that I would like to resolve this now before it gets out of hand. And now means tonight. And Z, if I get a call or a text from anyone involved in this other than you, Zhang, or the chairman, I will make certain that between the man sitting next to me and every person he knows and my ability to forever hold a grudge, that you will regret not following my direction. I am sitting here waiting for the call with my father. That's Vice President Joe. Communications like these made it clear, says Gary Shapley, the IRS whistleblower, that we needed to search the guest house at the Biden's Delaware residence where Hunter Biden stayed. In September 2020, we had a prosecutors meeting. The assistant U.S. attorney who we saw yesterday, Leslie Wolf, told us there was more than enough probable cause for a physical search warrant there. But question was whether the juice was worth the squeeze. She continues, she says that optics were a driving factor in the decision on whether to execute a search warrant. She said a lot of evidence in our investigation would be found in the guest house of former Vice President Biden, but said there is no way we will get that approved. The prosecutors even wanted to remove Hunter Biden's name from electronic search warrants and other document requests. Special Agent so-and-so said that he felt uncomfortable with removing his name. That's unethical. His concerns were ignored. DOJ tax attorney Jack Morgan said, doing it without Hunter's name would still get us, most of the things we want. But I've never understood to be part of an investigation where most was sufficient. On September 3rd, the slow-walking process continued. Leslie Wolf, again from the DOJ, stated that a search warrant for emails for Blue Star Strategies was being sat on by OEO. That's the DOJ office. He says, actually, I don't even know what it means, the acronym. She indicated that this warrant is likely not going to get approved. Again, because it's being covered up. This was a significant blow to the FARA piece of the investigation. You don't get your warrant. On September 4th, Deputy Attorney General Donahoe issued a cease and desist of all overt activities due to the coming election. So they delayed it long enough to get it into the election window. September hits. He goes, oh man, perfect. September, October, November, that's our 60-day window. Now I've got a precedent here. So stop all your investigation. Don't release anything. you're all stopped. U.S. Attorney Leslie Wolf made several odd statements as well. She included saying that the DOJ was under fire and that it was self-inflicted. She stated that the DOJ needed to repair their reputation. At the next prosecutors' meeting, September 21st, the FBI tried to dictate that we only do 5 of the planned interviews so FBI management could reevaluate if they want to continue assisting, because they're not going to come out and implicate Joe Biden again. They already did that with Hillary in the months leading up to the 2020 election, and they got blamed for losing this. Special Agent so-and-so said, it seems inappropriate for you guys to dictate, the FBI to dictate to the IRS who we should be interviewing. Later that day, I learned that the FBI case agent in Delaware had only recently moved back to his hometown of Wilmington with his wife and family, and he was concerned about the consequences for him and his family if they conducted those sensitive interviews and if they executed a search warrant on Biden's guest house. So then Gary Shapley emails Attorney Wolf from the DOJ. He says, hey, Leslie, we need to talk about the computer, all right? It appears the FBI is making certain representations about the device. And the only reason we know what is on the device is because of the IRS affiant search warrant that allowed us to get access to the documents. Says if Durham also executed a search warrant on the device, we need to know so that my leadership is informed. My management has to be looped into whatever the FBI is doing with the laptop. It is IRS's responsibility to know that. Let me know when I can be briefed on this issue. So he sends that to the DOJ. My email led to a special meeting on October 22nd with the prosecution team and the FBI's computer analysis team to discuss the Hunter laptop. We once again objected that we still had not been given access to the laptop. So they're not even going to let IRS investigate it, even though they know it's Hunter's and they have an open investigation into Hunter. Incredible. Special Agent Redacted asked about the full filter review copy of the contents. So he stated that he had not been provided with the data. Leslie Wolf also stated that she would not have seen it because, for a variety of reasons, prosecutors decided to keep it from the investigators. No reason why. He says, this decision is unprecedented in my experience. Why? Don't know. Investigators assigned to this investigation were obstructed from seeing all of the available evidence. It's unknown if all the evidence in the laptop was reviewed by agents or prosecutors. No idea. So based on guidance provided by the prosecutors on a recurring basis to not look into anything related to Biden, there's no way of knowing if evidence of other criminal activity existed concerning Hunter or Biden. Prosecutor Leslie Wolf acknowledged there was no reason to believe that any data was manipulated on the devices by any third party. She further supported this belief by mentioning that they corroborated the data with other sources of information received. And when Tony Bobulinski came out in the October of 2020, this was all being corroborated at that time because we had public sourcing that could match up the dates in the emails to the news reports of where Joe Biden was traveling. Also, on October 22nd, 2020, just weeks before the election, on a prosecutor team call, Leslie Wolf, the U.S. attorney, stated that United States Attorney David Weiss had reviewed the affidavit for a search warrant of Hunter Biden's residence, and he agreed. Probable cause had been achieved, which means you submit it to a judge, judge signs off on it, let's go. Even though the legal requirements were met and the investigative team knew evidence would be in these locations, Leslie Wolf stated that they would not allow a physical search warrant on Hunter Biden. Why? The case agent and I raised the issue to IRS leadership continually, including January 16, 2020. I stated, DOJ Tax has made a concerted effort to drag their feet concerning conducting search warrants and interviewing key witnesses in an effort to push those actions to a time frame where they can invoke the DOJ rule of thumb concerning affecting elections. Exactly. They just delay, get it into the election window and squeak through the election. No follow-up questions were asked and no action was taken by IRS. Because the 2020 election was contested, our original plan to go overt on November 17th was also delayed. The DOJ pushed back against the day of action because they did not want to approach Hunter while he was in Delaware, co-located with President Biden. So even after the election, like, oh, well, it's contested. There's always an excuse to delay. U.S. Attorney, and here we are, it's 2023, by the way, and when they just worked out a plea deal. Isn't that amazing? U.S. Attorney Weiss stated on November 10, 2020, that he had to delay the day of action because it was contested. He also stated that because there was no leak in the investigation, it's not public, primary focus is protecting the integrity, which means keep it concealed from the public. So then we began preparing for our day of action, December 8th. That included document requests and 12 interviews around the country. The search warrant had been rejected by the DOJ, and we included the possibility of a potential consent search of Biden's residence, which was a Hail Mary. Maybe he'll just let us in and look around. On December 3rd, after the election, we had a 12-hour-long meeting at the U.S. Attorney's Office with the prosecution team. Weiss came in at the beginning of the meeting and jubilantly congratulated the team for keeping the investigation, quote, a secret. Great job, everybody. We kept it secret. The election's over. Our guy won. He's thrilled. Way to go. We kept this whole thing a secret. Weiss was in and out for the rest of the meeting, but it went downhill from there. We shared with prosecutors our outline to interview Hunter Biden's associate, Rob Walker. Among other things, we also wanted to question Walker about an email that said, 10 held by H for the big guy. 10 held by H for the big guy. Wonder who that could be. The big guy. Joe! We had obvious questions like who was H, Hunter, who was the big guy, and why this percentage was to be held separately with the association hidden. How come? But when we were going through this, the U.S. Attorney Wolf interjected, said that she did not want to ask about the big guy, and stated that she did not want to ask questions about Dad. When multiple people in the room spoke up and objected that, hey, we have to ask that, she responded, well, there's no specific criminality to that line of questioning. So this Leslie Wolf character is a real something, actively impeding this. Keep an eye out for her. She'll probably be the Attorney General one day. This upset the FBI too, and I'll explain in a moment. The IRS and FBI agents conducting this interview tried to skirt U.S. Attorney Wolf's direction. Hunter Biden was assigned Secret Service protection around December 3rd. So we developed a plan then for FBI Los Angeles, a special agent in charge, to reach out to Secret Service Los Angeles, and tell them we're coming to seek an interview. However, the night before they were going to go interview Hunter, on December 7th, I was informed the FBI headquarters had notified Secret Service headquarters and the transition team about the plans. They tipped off a group of people very close to President Biden, and Hunter gave this group an opportunity to obstruct and approach on the witness. The night before, FBI had notified Secret Service, so the IRS investigators couldn't go investigate. The next morning, when I saw my FBI counterpart, Special Agent Joe Gordon, he was clearly dejected about how our plan had been interfered with. FBI Supervisory Special Agent Gordon memorialized the new plan in an email on the morning of December 8th that stated the subject and the Secret Service protectees would be given the phone numbers, and the subject would call us asking if he wanted to speak with us. So they're going to try to get Hunter on the phone. So Gordon and I waited in the car outside of Hunter's California residence waiting for a phone call. It was no surprise that the phone call Gordon received was from his friend, Assistant Special Agent in Charge Alfred Watson. He said that Hunter's going to contact us through his lawyers. All right. Hunter's not calling you guys. His lawyers are going to call. They're trying to talk to him so they can ask him questions. Hey, Hunter, what about this email? Hold 10 for H and 10 for the big guy. What does this mean? But now he's all lawyered up because the DOJ and the FBI tipped off his people. We received a phone call later that morning from Hunter's lawyers who said that they would accept service if you have any documents, but we couldn't talk to him. Yeah. The public news of our investigation hit the press the next day. Now, I can't know for certain, says Shapley, whether FBI's advance notice played a role or not, but of the 12 interviews we hope to conduct on our day of action, we only got one of them. Everybody else got tipped off. So of the 12 they had scheduled, one happened. Everybody else got tipped off. It was with Rob Walker in Arkansas, and it was exactly the sort of interview we expected to have if the FBI hadn't tipped off Secret Service and the transition team. In the interview, FBI agent Rob Walker tried to get him to talk about the 10 held by H, while not directly contradicting Wolf's direction to not ask about the big guy. So Wolf specifically says, you're not allowed, right? I'm a prosecutor. I work for the DOJ. We're kind of above you guys because you can't bring any of your investigations into criminal charges without us. So she says, don't ask about the big guy. So the FBI agent's trying to be sneaky about it. He said, this is a quote. He's asking Rob Walker, the famous email that Tony was pointing out, like the equity split. Can you tell me your opinion of that? When it's going through, like, 10B ... held by H. So he doesn't actually say the thing. So man, he really wants to dig into this. And he's basically asking the question that he's prohibited from asking. All right. Walker answered and responded. He said, I think that maybe James was wishful thinking, and maybe he was just projecting that, if this was a good relationship and this was something that was going to happen, the VP was never going to run, just protecting that, maybe at some point he would be a piece of it, but he was just more, it looks terrible, but it's not. I certainly never was thinking at any time the VP was a part of anything we were doing. And yet it was clearly valuable for the investigators to ask about Hunter's dad, as Walker went on to describe an instance in which the former vice president showed up at a meeting. We were at the Four Seasons and we were having lunch and he just stopped in, just said hello to everybody. I don't even think he drank water. I think Hunter Biden said, I may be trying to start a company or try to do something with these guys, and could you? And I think he was like, if I'm around, he'd show up. FBI agent asked, so, Mr. Walker, so you definitely got the feeling that that was orchestrated by Hunter to have like an appearance by his dad at that meeting just to kind of bolster your chances at making a deal work out? Walker said, sure. And any times when he was in the office, or did you hear Hunter say that he was setting up a meeting with his dad with them while he was still in the office? Yes. And inexplicably, the FBI agent changed the subject. I can see why. That's really bad for Joe. On December 10th, the prosecutorial team met again to discuss the next steps. One piece of information came out the day of action was that Hunter Biden vacated his office in D.C. Documents all went to a storage unit in Virginia. The IRS prepared a search warrant for the unit, but Leslie Wolf, DOJ, once again objected. Shapley says, my special agent in charge and I scheduled a call with U.S. Attorney Weiss to talk about that issue. We want to go and get the storage room. Weiss agreed that if the storage unit wasn't accessed for 30 days, yeah, we can get a search warrant. No sooner had we gotten off the call with David than Leslie Wolf had simply reached out to Hunter Biden's defense counsel and told him about the storage unit. I've never heard of anything like this. Prosecutor is literally calling the lawyer and saying, hey, they're coming for your storage unit. IRS calls the U.S. attorney in charge in Delaware, David Weiss. Leslie Wolf should be subordinate to David Weiss. Now, my question is, did David Weiss, is this like a good cop, bad cop routine where David Weiss is pretending to be the good cop? And so he gets the call. He says, hey, these IRS guys are coming for the storage unit. He passes that off over to Wolf. So she calls the counsel because Weiss can't call counsel. Listen, my friends, a prosecutor literally calling a defense lawyer and giving them evidence that's going to prevent their client from being charged on a case that the prosecutor is working on is so corrupt, it's disgusting. And so this is once again ruining our chance to get evidence before being destroyed, manipulated, or concealed. This guy, it's like Game of Thrones, man. He shows up and is explaining what he expects to be his own side. And he shows up and they stab him in the back 35 times. My special agent in charge at the time emailed that she would be informing the director of field operations of her, quote, frustration with the U.S. Attorney's Office for not allowing us to get a search warrant. Shapley says, to this day, I have no way of knowing if the documents from that unit were among those that were ultimately provided to our team. This was the second search warrant where prosecutors agreed that probable cause was achieved but would not allow investigators to execute. A clear indication of preferential treatment of Hunter. In a briefing that I requested to the director of field operations, investigators mentioned the possibility of blowing the whistle on how the DOJ was handling the case. This was back in 2021. My special agent in charge disengaged and was minimally involved moving forward. He says this same sort of unprecedented behavior continued throughout 2021. He says, I wrote my chain of command this in a memo, May 3rd, 2021. He said, this investigation has been hampered and slowed by claims of potential election meddling. Through interviews and review of evidence obtained, it appears there may be a campaign of finance criminal violations. U.S. Attorney Wolf stated on the last prosecution team meeting that she did not want any of these agents to look into this allegation. She cited a need to focus on 2014, that we could not yet prove an allegation beyond reasonable doubt, and that she does not want to include their public integrity unit because it would take authority away from her. We do not agree with her obstruction on this matter, is what he says. After we shared on August 18, 2021, multiple times thereafter about interviews that we had planned, Wolf emailed us, says, I do not think you are going to be able to do these interviews as planned. She says, sorry, those require approval from tax. Delays extended through September into October. Then they raised other objections. Part of what we examined were charges made with Hunter Biden's card that might conceivably have been done by his children. But U.S. Attorney Wolf told us it's going to get us into hot water if we go into President Biden's grandkids. So as a result of this behavior, I went to my director and I expressed how poorly the DOJ was handling this case. Despite these obstacles, around this time, Special Agent so-and-so began drafting a Special Agent Report, a SAR, which is a document in which the IRS recommends that charges be brought. But another troubling issue occurred with IRS criminal tax attorneys, known as CT Counsel. They reviewed the document, and one attorney called Chris Steinbrunner worked with the case agent to get questions answered and to understand the evidence. She indicated to the case agent that she was going to concur with all the recommended charges. Feb 9, 2022, tax counsel at the national office reached out to the co-case agent, and they all agreed they concurred on the charges. But then, once they all agreed, it went up to leadership, Rick Lunger, Elizabeth Hayden, and they directed Steinbrunner to change it, non-concur for all charges. Supervisors were mentioned and called, and they said, no, it was always a non-concur. We never said it was a concur. And they said, no, you're lying. You're misrepresenting the facts. You changed it. So in a documented exchange, somebody sent Steinbrunner, and Steinbrunner corrects herself. Did you know that they were saying that it's always been a non-concur? Steinbrunner says, what? No, I sent them a yellow light. You were wrong. So she just changed her opinion. He says, I have no idea why anybody would provide false information on this topic. Since the counsel is only advisory, the IRS sent the SAR to tax. Now, at some point, Leslie Wolf supported charging Hunter for various charges, and there was a 90-page memo recommending prosecution. But we had to fight over venue. Where is the appropriate place to bring charges? D.C., California? One of those two is correct, not Delaware. I requested to bring this case in D.C., but I was denied. Tax telephoned the case agent, and a couple of days later, Mark Daley called the case agent back and told him that President Biden appointee for D.C., Matthew Graves, personally reviewed the report and did not support it. We in the IRS didn't realize at the time that there was no ability to charge there. Then Merrick Garland appeared in front of Senate Appropriations. Bill Hagerty asked him, how can we be confident in you, Merrick, that you're doing an investigation properly into Joe Biden and his son? He said, well, because we put the investigation in the hands of a Trump appointee, right? That's David Weiss, who is the U.S. Attorney for Delaware, and because you have me as Attorney General, who's committed to independence. Yeah, right. We believe you, Mayor. The Hunter Biden investigation is being run and supervised by Delaware. He's in charge of this investigation. There will not be any interference of any political or improper kind. But we already know now that Biden's U.S. Attorney, Matthew Graves, did not support the investigation. But the DOJ said and led us to believe that David Weiss had special authority to charge in this case. I was under impression that they were still investigating him. But no, Weiss told them that he could not charge those years. The process meant that no charges would ever be brought in D.C. The statute of limitations would already expire. They just kicked it down the road. 2014, 2015 were too old. The years in question include, these are important years, foreign income from Burisma and a scheme to evade his income taxes through a partnership with a convicted felon. So those years have to go away. There were also potential charges from FARA relating to 2014 and 2015. The purpose of exclusion sanitized the most substantive criminal conduct and concealed material facts, which is why they didn't want them in. It's so gross. Hunter still has not reported approximately $400,000 from his Burisma income, has not paid taxes of about $125K, after being told multiple times to amend his returns by Eric Sherwin. And to make matters worse, defense counsel was willing to sign statute of limitations extensions and had done so several times. But because Attorney Weiss had no ability to charge, the DOJ allowed the statute of limitations to expire. There is no mechanism now available to collect those taxes. So Hunter got away with it. That money is gone. May 2022, Shapley says, I got a call from Gordon. He was going to brief FBI leadership. He told me that his field office thought they should push the case to go to a special counsel. I relayed about asking for a special counsel. My director says I wouldn't even know how to go about that. It's common practice for the DOJ for case agents to talk about and testify in court. However, it's much more unusual for management to ask for conversations because it's not discoverable. But in March 2022, the DOJ requested, DOJ asks from the IRS and from the FBI all management level emails about the Hunter case. He says, I didn't produce my emails, but I provided them with my sensitive case reports and my memorandums, including documentation of the DOJ's unethical conduct. Okay, so this guy's keeping notes this whole time. Much of that information has already gone up to my chain of command over 2 years over how this was unethical handling by the DOJ. Now, I didn't hear anything back, leading me to believe that no one even read anything that I gave them. He's like, I gave him everything, but I don't think anybody actually read it. So then, in our July call, Wolf told us that the United States Attorney, July 29th, not that long ago, 2022, indicated that at the end of September would be the goal to charge 2014-2015, because they didn't want to get closer to the midterms. The X factor on timing will include any delay defense counsel has requested. So 2 weeks later, Shapley says, I learned how the defense counsel felt about the case when prosecutors told us on a prosecutor team call that Chris Clark told them if they charge Hunter, they would be committing career suicide. Look at that. Wow. We had another meeting, and it took place October 7th. This meeting included only senior level managers from the IRS, FBI, and Delaware. He said this ended up being my red line meeting in our investigation for me. Weiss was there for the meeting. He surprised us by telling us on the charges. He said, I'm not the deciding official on whether charges are filed. Okay? Shapley is sitting in a meeting with Attorney Weiss, who we've been told, lied to by Merrick Garland, that he has the only authority to bring charges against Hunter. He says, I'm not the deciding official whether they're filed. Total lie. So he then shocked us with earth-shattering news that the Biden-appointed D.C. U.S. Attorney Matthew Graves would not allow him to charge in his district. You can't file here. To add to the surprise, Attorney Weiss also stated that he subsequently asked for special counsel authority from DOJ and was denied. This was troubling because he stated if California does not support charging, he has no authority to charge in California, and he was denied. All the massive amounts of foreign money Hunter received from Burisma for nothing. Weiss also told us that the new U.S. Attorney in California declined to support charges and would have to request authority again from Merrick Garland. Now, he says, I couldn't understand why the IRS wasn't told in the summer of 2020-22 that the D.C. had already declined charges. Everyone in that meeting seemed shell-shocked. I felt misled by Delaware. The meeting was very contentious and ended quite awkwardly. He walked into Weiss's office. He says it would be the last meeting I had in person with him. We had one more call 10 days later. Weiss wasn't on the call. In response to questions about subpoenas, we were told no grand jury any longer exists. Sorry, you're done. I shared with leadership how inappropriate the whole situation was. I emailed saying the U.S. Attorney's Office was so eager to get my emails, which they already had 90% of, says I would direct themselves to their own conduct. I documented issues that I would have addressed as they occurred, but every single day was a battle to do our jobs. I continually reported issues up the chain. Now, because they realize I documented their conduct, they separate me out. They cease all communication. Now they're attempting to salvage their own conduct by attacking mine. This is an attempt by the U.S. DOJ to tarnish my reputation. I hope IRS applauds the incredibly difficult position I've been put into, instead of entertaining U.S. attorney attacks. If they bring up something legitimate, I'm sure we can address it, but it was not intentional. everything I do is with the goal of furthering our mission, protecting fairness of our tax system, and representing the IRS with honor. And after my first attorney sent a letter to Congress in April, I started to hear rumblings the DOJ was picking the case back up. I don't believe that would have happened if it were not for me blowing the whistle. So shout out to Gary Shapley. They were going to button this whole thing up. He sends a letter to Congress. Grassley starts screaming from the rooftops. We get a little bit of a plea deal, but now the rest of this hatch has been opened. However, on Monday, May 15th, Special Agent in Charge told me DOJ requested an entirely new team from the IRS, and none of the 12 agents would be able to work the case. He says, that seems to me like clear retaliation for my disclosures. And what's worse is after Special Agent Blank emailed the commissioner to point out the human cost of the IRS from them implementing this retaliation, my assistant special agent in charge threatened him with leaking material. So they're being threatened now. And my special agent in charge sent me and other supervisors an email at the same time that said we had to stay within our chain of command. I interpreted this as a clear warning to me and anyone else who might be thinking of blowing the whistle. Shapley says, wrapping up, I did not choose to sit here before you today. I was compelled by my conscience. When the decision after decision has been made to deviate from our normal investigative processes, I believe Congress needs to know this information. I trust you'll do the right thing because we have nothing if I can't trust this body. Have I been saying William this whole time? Gary Shapley, correcting the record. Gary A. Shapley Jr., absolute hero for coming forward, facing, I can't even explain how much pressure is coming down to bear upon this man right here.